The next question that comes logically is if there was a proper arbitration initiation, as the first step in arbitration is serving of notice to arbitration. In our case, we have submitted the notice to Mr. Twiggins as we have considered him as a contract administrator. We became aware only after the arbitration commenced that Mr. Twiggins is actually the employee of Abacus with the back office in Mighty. As we were not aware that there is a subcontractor on the project, we were unable to distinguish Abacus from Mighty, and we have served the notice as a reasonable observer should anticipate that Mr. Twiggins is the person in charge. We have evaluated several cases here. First one is Glencore Architectural versus Conqueror Holdings Limited, where it was ruled that an employee who was employed as an operator did not have authority to handle any legal disputes arising from the operation he was responsible of. Similarly, in the Burnett Lines Limited versus High Sea Shipping Limited, it is held that the party initiating arbitration should not inform the party receiving notification about the email they intend to use. As we said before, we didn't agree about the way and about the details, any details, telephone number, email, fax, where we should submit a request for arbitration. In our case, although we have thought that Mr. Twiggins is an employee of Mighty, the parallel could not be made, as Mr. Twiggins acted as an agent, as a subcontractor to Mighty, so he was not employee of Mighty, as it was suggested in the previous cases. By doing so, he had implied authority to do whatever he felt is appropriate with the consent of Mighty. Mighty gave him all free hands to do whatever he wants. As it is found later that the whole work was subcontracted to Abacus and that only Mr. Twiggins was aware of the construction works, which is the major part of this contract. This brings us closer to the ruling of Sino-Channel Asia Limited versus Dana Shipping and Trading, where a very similar situation took place. Ship owner was unaware that the charterer was subcontracted all works to the agent, and the ship owner was communicated with the agent falsely thinking that he represents the charterer. The central issue was whether an arbitration notice had been effectively served. So it is the question in our case as well. So it involves determining whether subcontractor, through his representative, had implied, actual or ostensible authority to receive service. If it did not have, the question was whether the charterer had ratified its receipt of services. The first question in our case is whether Mr. Twiggins had implied actual authority to receive the notice. We will review the circumstances of the relationship between Mighty and Abacus. The setup between these two parties shows that although Mighty had assumed liability under the contract, because we saw only Mighty as a contracted party, it did not have any role in the project and had not participated in the day-to-day operation or performance. All Mighty wanted was a margin. Abacus therefore had implied actual authority to accept service of the notice, and Mr. Twiggins had that authority as their representative. The second question is whether Mr. Twiggins had ostensible authority. The appearance given to the granite was that Mr. Twiggins was to be dealt with all issues, including receipt of the notice. The granite was unaware of the Abacus' existence at all, and the employment details of Mr. Twiggins, and it was fair and just that Mighty should bear the risk, Mr. Twiggins' failure to perform the obligations, by informing Mighty about arbitration. So Mr. Twiggins failed to inform Mighty. The case is slightly different than our case, as the decision is made by the sole arbitrator. So in that case, ship owner selected arbitrator. In our case, the arbitrator is selected by the RGU Law School, which is independent party. In the procedure of appointment of arbitrators, we have contacted RGU Law School after we did not hear from Mighty and have therefore fulfilled all obligations under our arbitration clause. Therefore, we feel that we have full and valid arbitration agreement. At the end, we wish to ask Tribunal to include Abacus as a third party to this arbitration in accordance with Scotland Third Party Act.